if the Court will just bear with me for 1 minute here. It's at page 11A of the appendix to our brief. It provides that a person can go to the Secretary of HHS and obtain a hardship exemption which would, as a formal matter here, excuse compliance with the penalty. It seems to me to make very little sense to say that someone who has gone to an official of the United States and obtained an exemption would nonetheless be in the position of being a lawbreaker. We think another way in which you can get to the same conclusion slightly differently is by considering the provision on the prior page, 10A, which is 5000A sub 3, members of Indian tribes. Members of Indian tribes are exempt only from the penalty as a formal matter under the structure of the statute here. But the reason for that is because members of Indian tribes obtain their health care through the Indian Health Service, which is a clinic-based system that doesn't involve insurance at all. It's an entirely different system. They were taken out of this statute because they get their health care through a different system. And it doesn't make any sense to think that persons getting their health care through the Indian Health Service are violating the law because they're exempt only from the penalty, but still under a legal obligation to have insurance. When the whole point of this is supposed to be
is your whole point
system.
that this was inartful drafting by Congress? That to the extent that there's an exemption under the penalty, it's an exemption from the legal obligation?
I guess what I would say about it, Your Honor, is that the way in which this statute is drafted doesn't permit the inference that my friends from the NIB are trying to draw from it. And there is an additional textual indication of that, which one can find at page 13 of our reply brief. This is a provision. It's 42 U.S.C. A, section 18022E. This is a provision that provides for a certification that certain individuals can get, and it's just the paragraph starting with the words "other provisions" contains the quote, and it says, an individual with a certification that the individual is exempt from the requirement under Section 5000A by reason of Section 5000A(e)(1) of such code is entitled to a certificate that allows for enrollment in a particular program for this category of people. But you can see here Congress is saying is an exemption from under 5000A(e)(1, which is the exemption from the penalty and not the underlying requirement, is, as Congress says, an exemption from the requirement of Section 5000.
So 5000A says directly, an applicable individual shall ensure that the individual has the minimum essential coverage. And you're saying that it doesn't really mean that. That if you're not subject to the penalty, you're not under an obligation to maintain the minimum essential coverage.
That's correct, and we think that's what Congress is saying, both in the provision I just pointed to, Your Honor, and by virtue of the way the exemptions work. I just think that's reading this in context, that is the stronger reading of the statute.
Suppose it makes it easy for the government to drop the other shoe in the future, right? You've been under the law subject to this mandate all along. You've been exempt from the penalty. So all they have to do is take away the penalty.
I don't think so, Mr. Chief Justice. I don't think it makes it easy for the government in the future. We think this is the fairest reading of the statute, and you cannot infer from the fact that someone is exempt from the penalty that they're still under an obligation to have insurance. That's just not the fairest reading of the statute.
Could I understand?
Go ahead. No, go ahead. Go ahead.
The nature of the representation you made, that the only consequence is the penalty. Suppose a person does not purchase insurance, a person who is obligated to do so under the statute doesn't do it, pays the penalty instead, and that person finds herself in a position where she is asked the question, have you ever violated any federal law? Would that person have violated a federal law?
No. Our position is that that person should give the answer no.
And that's because?
That if they don't pay the tax, they violated a federal law.
But as long as they've paid the penalty?
If they've paid the tax, then they're in compliance with the law.
Why do you keep saying tax?
If they pay the tax penalty, they're in compliance with the law. Thank you, Justice Breyer.
The penalty.
That's right.
Suppose a person who has been receiving medical care in an emergency room, has no health insurance, but over the years goes to the emergency room when the person wants medical care, goes to the emergency room, and the hospital says, well, fine, you're eligible for Medicaid, enroll in Medicaid. And the person says, no, I don't want that. I want to continue to get care here from the emergency room. Will the hospital be able to point to the mandate and say, well, you're obligated to enroll?
No, I don't think so, Justice Alito, for the same reason I just gave. I think that the answer in that situation is that that person, assuming that person, well, if that person is eligible for Medicaid, they may well not be in a situation where they're going to face any tax penalty. And
no, they're not facing the tax penalty. So the hospital will have to continue to give them care and pay for it themselves and not require them to be enrolled in Medicaid.
Right.
Will they be able to take this out and say, well, you really should? You have a moral obligation to do it. The Congress of the United States has said you have to enroll.
I think it's certainly fair to say that the Congress wants people in that position to sign up for Medicaid. I think that's absolutely right, and I think the statute is structured to accomplish that objective, but the reality still is that the only consequence of noncompliance is the penalty.
General, but I thought that people who were eligible for Medicaid weren't subject to the penalty. Am I wrong? I could be just factually wrong.
Well, the penalty is keyed to income, and it's keyed to a number of things. One is, are you making so little money that you aren't obligated to file a tax return? And if you're in that situation, you're not subject to the penalty. It's also if the cost of insurance would be more than 8% of your income, you're not subject to the penalty. So there isn't necessarily a precise mapping between somebody's income level and their Medicaid eligibility at the present moment. That'll depend on where things are and what the eligibility requirements are in the state. But as a general matter, for people below the poverty line, it's almost inconceivable that they're ever going to be subject to the penalty. And they would, after the Act's Medicaid reforms go into place, be eligible for Medicaid at that point.
So is your point that the tax, what we want to do is get money from these people. Most of them will get the money by buying the insurance, and that will help pay. But if they don't, they're going to pay this penalty, and that will help too. And the fact that we put the latter in brings it within the taxing power. But as far as this Act is concerned, about the injunction, they called it a penalty and not a tax for a reason. They wanted it to fall outside that. It's in a different chapter, et cetera. Is that the heart of what you're saying?
That's the essence of it. They called it a penalty. They didn't give any other textual instruction in the Affordable Care Act or in the Internal Revenue Code that that penalty should be treated as a tax for Anti-Injunction Act purposes.
You agree with Mr. Long, isn't it? And I thought you just agreed with Justice Breyer that one of the purposes of the provision is to raise revenue.
It will raise revenue. It's been predicted by the CBO that it will raise revenue, Your Honor. But even though that's the case, I mean, I think that would be true of any penalty, that it will raise some revenue. But even though that's the case, there still needs to be a textual instruction in the statute that this penalty should be treated as a tax for Anti-Injunction Act purposes, and that's what's lacking here.
After this takes effect, there may be a lot of people who are assessed the penalty and disagree either with whether they should be assessed the penalty at all or with the calculation of the amount of their penalty. So under your interpretation of the Act, all of them can now go to court. None of them are barred by the Anti-Injunction Act.
Those are two different things, Justice Alito. I think for reasons that Justice Kennedy, suggested in one of his questions to Mr. Long, all of the other doctrines, that exhaustion of remedies and related doctrines, would still be there, and the United States would rely on them in those circumstances. And so I don't think the answer is that they can all go to court.
Well, two former commissioners of the IRS have filed a brief saying that your interpretation is going to lead to a flood of litigation. Are they wrong on that?
Yes, we don't. We've taken this position after very careful consideration, and we've assessed the institutional interests of the United States, and we think we're in the right place.
But tell me something. Why isn't this case subject to the same bars that you list in your brief? The tax court, at least so far, considers constitutional challenges to statutes. So why isn't this case subject to a dismissal for failure to exhaust?
We don't, because the exhaustion would go to the individual amount owed, we think, and that's a different situation from this case. If the Court has no further questions.
Thank you, General.
Thank you.
Mr. Katsas?
Mr. Chief Justice, and may it please the Court, let me begin with the question whether the Anti-Injunction Act is jurisdictional. Justice Ginsburg, for reasons you suggested, we think the text of the Anti-Injunction Act is indistinguishable from the text of the statute that was unanimously held to be non-jurisdictional in Reed Elsevier. That statute said no suit shall be instituted. This statute says no suit shall be maintained. No material
maintained. And this says immediately, Reed Elsevier statute says immediately after instituted, unless the copyright is registered.
Unless the copyright is registered. And this goes to the character of the lawsuit. The statute in Reed Elsevier says register your copyright and then come back to court.
So why isn't that like a filing fee? Before you can maintain a suit for copyright infringement, you have to register your copyright.
It's a precondition to filing suit. The analogous precondition here is pay your taxes and then come back to court. The point is...
No, that's not true. The suit here has nothing to do with hearing the action. It has to do with a form of relief that Congress is barring. It's not permitting... It is not a tax case. You can come in afterwards. It's not permitting the court to exercise what otherwise would be one of its powers.
It has to be the same challenge, Justice Sotomayor, or else South Carolina versus Regan would say the Anti-Injunction Act doesn't apply. You are right that once you pay your taxes and then file the refund action, the act of filing the taxes converts the suit from one seeking prospective relief into one seeking money damages. And in that sense, you could think of the statute as a remedial limitation on the courts. But whether you think of it as an exhaustion requirement or a remedial limitation, neither of those characterizations is jurisdictional. In Davis versus Passman, you said that a remedial limitation doesn't go...
It does seem strange to think of a law that says no court can entertain a certain action and give a certain remedy as merely a claim processing rule. What the court is being ousted from what would otherwise be its power to hear something.
The suit is being delayed, I think is the right way of looking at it. The jurisdictional apparatus in the district court is present. Prospective relief under 1331, money damages action under 1346. If the Anti-Injunction Act were jurisdiction ousting, one might have expected it to be in Title 28 and to qualify those statutes and to use jurisdictional.
So how do you deal with this case and our recent Gonzalez case, where we talked about the language of the COA statute, that no appeal will be heard absent the issuance of...
Gonzalez against Thaler rests on a special rule that applies with respect to